Hi, Bill Henshaw here again today with yet another update in my ongoing Oakland case. And I've got a document to read here. Everybody I've talked to is stunned that this has happened. But I think I have a good idea of why it's happened. But we filed, as you know from listening to my earlier videos, and I suggest you do that and check out my videos on this subject, that we did the impossible and we got a non-statutory federal writ of habeas corpus filed in this case. And I did that, by the way, when I walked into the clerk's office with my friend who's the mom of the kid that's in jail. And we walked into the clerk, and I had the writ in my left hand and a federal civil complaint for treason in my right hand. And I said to the clerk, your choice. They filed it. That's what we're going to do to get our cases filed. But what I've subsequently learned from this order and from a case I'm going to read you excerpts from, this leaves no doubt whatsoever in anybody's mind what the hell is going on here. We got this, and I said, you got to be kidding. They never held a hearing, and it was on the same day I was actually in the quote-unquote courthouse with my friend and her son, who was never in the courtroom. He was in a holding cell the entire time, and whatever happened with this was in a different department called the writ department, or in some places the ex parte department, which is where you should hear a writ like this. No hearing, no opposition from the local dumbass, nothing. And this is what we get. It says this pro se petitioner, not who the hell we are, we're there in propria persona sui juris, people, as a belligerent claimant in person. U.S. v. Johnson, 76 Bedsup 538. Gets it wrong immediately. Writ of habeas corpus filed with the court on 11th September, is now on for a hearing, which is, that part's true. Petitioner is presently awaiting preliminary hearing in his case number, and says this court denied petitioner's Marsden motion. He gets it wrong again. That's in California. Marsden motion is when you go in and try to have the court declare that you're competent to represent yourself. What the hell is this? If we're incompetent, how could we be competent to form the criminal intent to commit the crime? Damn, Marsden. Remember that name. So, and it says the trial court, granted it the first time around. No, they denied it the first time. They granted it the second time. They denied it the third time, and currently it's on for a fourth hearing because he's had an appointment of counsel, which I think I mentioned the last time on the videos, in the situation where he wasn't even in the courtroom. He was upstairs in a holding cell. And it's a mea culpa for me because I missed that. I thought he was there because you can't see the in custody from most of the parts of where the visitors sit in the courtroom. I thought he was there. I thought I heard him accept counsel. None of that happened. So here we go, and this guy that wrote this has no clue what's happened here. It says the court has considered the petitions and attached documents and exhibits because of when the petitions were filed. No, he didn't. Petition is unopposed. There would have been nothing to consider. This is an adversarial form of government. Two people arguing. If only one shows up and argues, who wins? Now, a lot of you probably have some bitter experience with that when your opponent files some damn summary default 12b6 motion for a summary judgment and they rule against you because you didn't show up. This doesn't work the other way. What the hell ever happened to equal protection? Damn, unopposed writ. And we have multiple issues, any one of which will end this case. This judge obviously never looked at it, or he certainly didn't make any rulings on it. Hey, it goes on. It says, with limited exceptions, pro se documents, again, offered on appeal or for habeas corpus will be returned unfiled. Unfiled, or if mistakenly filed, will be summarily stricken from the record. What does that tell you? It doesn't matter how good you are, how long you studied law, how good your issues are. They don't care, and they don't think they have to. Then you're forced to take one of their attorneys, and with politically correct law being what it is under the non-existent 14th Amendment, when you accept an attorney, he's an officer of the court, and you thereby stipulate to the very jurisdiction we're challenging. That's what's so good about my recent epiphany on the right to counsel. Because I got it wrong for a long time. Mea culpa, when I'm wrong, I'm the first to admit it. You don't have to tell me. Because the deal here is it doesn't come from the 14th War Amendment. It comes from all 6 articles of the Constitution, without which we have no way to invoke any rights throughout that entire 6 articles. It means the Constitution is not there because they never bothered to teach us a damn thing in their mandatory public education system. There's no way to know it. If I had learned one thing 50 years ago about Andrew Johnson, for example, his vetoes of the Civil Rights Act and the Reconstruction Act and other things like that, my life would have been different 50 years ago. It would have dawned on me what the hell was going on and that Andrew Johnson was our greatest president. But as they're fond of saying in Langley, CIA, black is white, and you never hear a good word said about him. Only at the time I was in school, he was the only president ever impeached. We hadn't gotten around to Bill Clinton and Monica Lewinsky at that point. But that said, and he got impeached, by the way, people don't even know, and we didn't get taught in high school, for a violation of what was called the Tenure of Office Act. Now, I know this is straying a little bit here, but it's an important point for you to get, because he tried to fire his then Secretary of War, I'll think of his name in a minute, but his Secretary of War, and Congress said you can't do that. You need our permission if you're going to fire a member of your cabinet. Well, wait a minute. Congress is only in the act insofar as they have the power to review and approve the appointments that the president makes. And indeed, this law that he was impeached under was ruled unconstitutional 60 years later by the 9/01. So that said, it came down to almost the last vote in the Senate, and they voted alphabetically. I can't think of the guy's name. He was a senator from Iowa, and he voted against impeachment, and Johnson won by 1 vote. But all you ever heard was he was impeached, and never why, and never the real reason, because what he did was he told the truth and challenged the 39th War Congress that was passing all these crap laws that the people didn't understand, and he was bringing it to their attention. That's what happened there. So that said, we return back here, and now we see we have exactly the same situation again. And it goes on, the last paragraph says, the allegations in the petition, which are not on the Judicial Council forums, as if that matters, are quote-unquote unintelligible. When I get this bastard in front of the bargaining table and sitting down discussing how much they're going to be paying us, I'm going to say to him, do you really want me to get your sorry ass up there in front of a jury and ask you unfiltered by one of your attorneys if all of the events at Independence Hall in 1787 in Philadelphia are also unintelligible? Damn, this is going to be a quick hit or win. They can't have this happen. And I think this judge, and I don't know, I may owe him a mea culpa, and I'll tell you about that next time we do videos. But I think he may have realized he finally has somebody here who's doing paperwork who understands it. And he wanted to make this so bad that it's going to not only get rid of this case, but it's going to help us get down the road in all of our other cases, perhaps yours included. And I'm going to read you some excerpts to show you what I mean. In the case he cited here called People v. Mattson, M-A-T-T-S-O-N. And by the way, the viewers, any of you that send in requests for information, I'll give you a copy of this, courtesy, free copy, and a copy of the Mattson case, and you can look at it yourself. It's not me saying it. But that said, some of the excerpts from this Mattson case of the California Supreme Court talking about attorney and client, and it says, as has been stated before, the constitutional and statutory provisions that defendant has the right to appear and defend in person and with counsel. Defendant is not entitled to have his case presented in court by both himself and counsel acting at the same time or alternating at the defendant's pleasure. The letter I wrote to the State Bar Association about this in capital letters, I said, wrong-o. That's not the way it works. Attorney-client, and understand this, people, that relationship with you is principal and agent. Not only are they your agent, they're the agents of your agents of the state government that created the State Bar to start with. You tell them what you want them to do. This is what you wish. That's how a sovereign individual is able to do things. The Queen of England says she wishes you to do this, you better damn well do it. Well, the same thing here. And that's because, again, this right to counsel does not come from the 14th Amendment. You're not a slave. You don't need all this BS assistance of counsel, which is, by the way, counsel sleeping through a large parts of a death penalty case where the death penalty was imposed was ruled not to be ineffective assistance of counsel. What the hell value is that? I mean, I'm just telling you, it's just unbelievable. So it's wrong about that. And it goes on and says, so long as the defendant is represented by counsel at the trial, he has no right to be heard by himself. Shit, what does it take here? That's your life and your liberty that you're at stake, and you have no right to be heard? That's what they think. And remember, you accept their counsel. That's in effect a stipulation to the jurisdiction we're trying to challenge. That's what's so important here, because the way we're doing it, we're saying no, counsel under the first 6 amendments with no stipulation whatsoever. The local dumbass has to prove jurisdiction. We don't have to defeat it. They have to establish it. That's how important it is. So it goes on. A fundamental reason for according to the accused the right to counsel is that without the aid of an attorney or other protections which the law affords would often avail defendant little, since it cannot be assumed he is sufficiently articulate and adequately conversant with the constitutional and legal rights and his procedural duties to protect himself throughout the course of criminal proceedings. Damn, that's what the judge is there for, a supposedly neutral fact finder, to be sure this doesn't happen. But they're right. Can't be assured he's sufficiently articulate and adequately conversant, since they damn well didn't teach us a thing in their public mandatory school system. You have no way to know it. So not only you need counsel, but you need to be able to actively assist him at the same time and point out when he makes errors and bring it to the attention of the court to set the record that's going to get reviewed properly. Simple. The coup de grace here. Common knowledge of judges and attorneys, and to some extent the transcript in this case is here and after pointed out, suggests that there are at least some persons who, although not members of the bar, undertake to act as their own attorneys. Not what we're doing, people. Not pro se. You're not there pro se. In propria persona sui juris, of their own right. Undertake to act as their own attorney. No. In presenting their case or defense, and who in acting do not appear to feel bound to maintain the respect due to the courts of justice and judicial officers. Son of a bitch. You're sitting there as a black-robed bastard, and you know the court doesn't have jurisdiction. You certainly know it if you've read documents you can get from me putting them in there from day one on the case. And he knows or should have known they don't have jurisdiction and has refused to dismiss the charges? Can you tell me what respect a bastard like that deserves? I never call him your honor, quote unquote. They're in a position of honor, profit, and trust in the de facto national government. But they have no honor. That's it. Just a fact. I've seen very few. This judge in this Oakland case may turn to be one. I'll get back to you on this one. But there's so few of them. Because they don't have it, and you couldn't care less about you or give a damn, and they don't think they have to. That's what you and I, viewers, have to change. And I'm getting pretty far down the road with this case and some other cases I'm working on at the same time. And they're going to find out if you act in a court without jurisdiction, legally that's called coram non judice. You can look it up in your Black's Law Dictionary. Acting not like a court. If you do that, you can't possibly claim any immunity, particularly judicial immunity. It doesn't exist. And that pulls the rug right out from under them. And in addition to that, since they're not in a state, and we can prove, I got an 80-page brief you can get by getting my materials. Just send me an email at youwinnincourt@gmail.com. 80-page brief on this issue, admission of new states. They're not states. Therefore, guess what happens? The judges and the DAs and whoever that want to claim 11th Amendment immunity can't do it. They're not in a state. They're in a territory. And I would have a real problem if they were in a state, but happily that's not what's going on here. But no 11th Amendment immunity either. And the cops that are often the only witnesses against you in a criminal case, not true, I think, in the Oakland case. We may actually have a quote-unquote injured party here, but it's irrelevant. But the cops that go in and testify against you think they have absolute immunity for any and all perjury committed on the witness stand. Okay, the 904 said that in Briscoe v. Leahy, 460 U.S. 325. And that's what they think. But again, if they haven't arrested you without a warrant and or probable cause, the arrest was null and void from day one for that reason. And they're damn lucky you didn't invoke your right to self-defense, because you have a right to do that. That's a video for another day, but the Supreme Court has ruled on that one also. But these are a lot of the things that has to change before, we get this system to stop and do what they did, in the case of the jaywalking arrest made almost within eyesight of where I am right now. 4 cops took this guy down, a la Eric Garner in New York. It's a strikingly similar situation. And they beat him and they tased him. One guy tased him 6 or 7 times and caused him to die of a heart attack. And yet, locally, our recent local dumbass here cleared all the cops of any wrongdoing, and they were cleared by an independent police commission of any wrongdoing. Now, you tell me, that's second-degree murder, just like it was with Eric Garner and some other people we can name, Oscar Grant, too, for example, at the Fruitvale BART station. And yet that Johannes Measley got, what, a year and a half, and they let the bastard go early on good behavior. Who the hell do you think he is, Felicity Huffman? Damn. So this is what needs to change. Some of these cops have to start going to jail for 15, 25 years to life. That's going to change things. But I don't think we're going to get a serious change, though, unless we rein in the POA's political activity committees in the state capitals. They have so much clout there, they can get virtually whatever they want enacted by a legislature. And happily, you'll learn from my materials. You can beat every law they enact for a variety of reasons. But the plain fact of the matter is they have that much power, and they have enough clout to threaten, on a local level anyway, officials running for office or running for re-election. Because adverse publicity will often get them defeated and out of office. And that's not the definition of a Republican government, no matter how you define it. For another day, we'll get into that. It's Article 4, Section 4. And a quick note about that, when you know the 9 old farts in 230 years have ruled on that issue one time. Once. We're going to fix that one, too. But that said, this Oakland case is getting better and better, and I've got some love letters going off that I'll make available later, to the governor, the Chief Justice of the California Supreme Court, the local dumbass, and saying, hey, cut your losses, do the right thing. Everybody here knows you don't have any jurisdiction. Don't keep the pretense up anymore. It's what's called in chess, zugzwang. No matter what they do, I'm going to beat them. It's just a matter of how long it's going to take. So that said, wow, and we'll have more on this next time probably. But that said, remember, to like my videos, subscribe, tell your friends, and send me an email at youwinincourt@gmail.com. Thank you.